I think I'd be remiss if I didn't at least say it's a date that I think all of us takes a little bit of time to remember what happened on that date that affected all of us and still affects all of us, and that we should all take some time just to reflect. I'm not going to say, let's do a moment of silence or that sort of thing, but I think, all of us, I'm sure, remember where we were and what are the astounding sort of impact that 9/11 had on all of us. So before we jump into the astounding impact of what is happening with our Supreme Court, I think we may want to just give a little bit of thought to the impact of what today is in terms of anniversaries and dates and things like that. So having said that, let's move to other astounding things. We have two amazing women who are going to talk with each other as well as with us about the state of SCOTUS, the Supreme Court of the United States, and whether or not we should have some trust in this court. And what does that mean if we're all feeling a little leery about the court right now? So let me tell you just briefly, because our announcement about this meeting gave you bios of Carolyn Shapiro and Colleen Connell. I'm going to repeat a little of what was in those bios, and you'll understand why we thought it was important to have these two women with their backgrounds to talk. And then I put together and shared with them in advance some questions and comments about what is happening here and now with this court. But feel free to use the chat box to put your questions in as we go. And I'll try to keep checking it. I'm on my iPad. As I said, I'm in California. I'm sitting in my granddaughter's bedroom. So, I'll try and keep checking it. But when we get to a point where we can go to the questions, we'll try and take questions from the chat box. Because it's my iPad, I can't see everyone. So someone else who can, if you raise your hand, that sort of thing, I'll try and get to you. And we can have a discussion about this really, I think, important and sort of dumbfounding kinds of things that are happening with our courts. And let me just say, I don't think it's just the Supreme Court. So I think we need to be conscious that our state courts, particularly our state Supreme Courts, need to be taken into account as well. So let me tell you a little about Carolyn and Colleen. And I guess your name has to begin with a C if you want to be a part of this panel today. So you have Carol, Carolyn, and Colleen. Okay. So Carolyn Shapiro is Associate Dean, Academic Administration and Strategic Initiatives, and co-director of the Institute on the Supreme Court of the United States, and professor at Chicago-Kent College of Law. Okay. Professor Shapiro is the founder and co-director of Chicago-Kent's Institute on the Supreme Court of the United States. So that right there and there, Carolyn should know a little bit about the Supreme Court, I would think. Her scholarship focuses on the institution of constitutional democracy, in particular, the Supreme Court of the United States, and how those institutions interact. She has argued cases in the US Supreme Court the Seventh Circuit, the Illinois Supreme Court, and the Illinois Appellate Courts. She earned her BA in English from the University of Chicago, an MA from the Harris School of Public Policy, and a JD from the University of Chicago College of Law. Okay. Colleen Connell is the executive director of the ACLU of Illinois. In 2001, she became the first woman attorney to lead the ACLU of Illinois. Under her direction, the ACLU of Illinois has adopted a strategy of integrated advocacy using every tool at its disposal strategically and in concert to defend and expand fundamental liberties and rights in the most effective ways possible. She has litigated rights of the mentally ill, equal access to education, housing discrimination, employment discrimination on behalf of women, freedom of speech and association, and before the U.S. Supreme Court, cases involving women's right to control their own reproductive health. She's a native of North Dakota, and Colleen graduated from North Dakota State University and the University of Iowa School of Law. Now, what I'm going to do is sort of give a little background and on the questions I'm going to ask, and then I will let either Colleen or Carolyn jump in and the other can follow, and they can go back and forth. I have a grand total of 5 questions, which is probably way too many for the approximate 40-45 minutes that we've sort of have to go over things. If those of you who are in the audience really are rabid to jump in on one of these questions, you know, start waving your arms or something, and someone who can see the full screen of people can say to me, Carol, you have to let somebody else in. Okay, we'll do it that way. So here's my first question. And do use the chat box. If you have a question, you can write out. All of the lower federal court justices must adhere to a code of ethics. The Supreme Court does not, at least not at this time, have such a code and is not required to adhere to one. Why do you think this is? And how does this impact the actions and behaviors of the justices and the public sense of who has influence on the court? Is this, do you think, something new, or has this been around and we are now just seeing it as important with this particular court and with certain justices on this court? And what would the reasons be for that? Now, Colleen, Carolyn, which of you would like to start us off?
Well, I'll start. You know, I don't know the answers to all of the questions. It may not be what you want to hear me say, but I think it's historically the code of conduct for judges has applied only to lower court federal judges, and their states have their own codes of conduct. The Supreme Court has said for a long time that it looks to the code of conduct that is in place for lower court judges when the individual justices make their decisions about things like recusal or other aspects, other ethical questions that may arise. That there are reasons why the Supreme Court, at least arguably, should be or might be subject to something different from the lower federal courts. For example, if there's a recusal requirement on the lower federal courts, it's pretty simple to ensure that there will be enough judges around to hear whatever case is at issue. There's some concern that if there are the more rigid recusal requirements are in the Supreme Court, the more likely it is that a number of justices won't be able to be involved in hearing cases or any particular cases. So that's one reason why there might be a difference. But the Supreme Court justices are required to provide disclosure information, like all federal employees. They have to disclose certain information about the types of things, that gifts that they receive in particular, or certain types of transactions that they engage in. And a lot of the current controversy that we're seeing, in particular around Justice Thomas and Justice Alito, have to do with whether or not they are actually complying with those rules. Colleen, I don't know if you want to add anything to that.
No, Carolyn did a really lovely job of summarizing why the Supreme Court in some ways is different than lower courts. I just want to lift up a statement by Justice Alito that I profoundly disagree with, that deals with ethics. And he suggested that the Supreme Court was beyond regulation with respect to ethics, because that would raise, because Congress, quite frankly, lacked the authority under the Constitution to do that. I think that when you look at the language of the Constitution, including the language in Article 3, which is the judicial article, and the fact that Congress has the constitutionally granted authority to actually create, in some ways, let me just say, to rule on or legislate on what the court's jurisdiction is, what kind of cases it can hear. Congress can set and does set a number of justices on the court. So I think that Justice Alito really grossly misrepresented the authority of the Constitution to allow some governance of the court. And I think that some of the ethical laws that are under consideration, or bills that are under consideration by the Congress right now, might very well be constitutional, except, as we know from Marbury versus Madison, in the early days of the Supreme Court, the court is of the view, and I share that view, that it is emphatically the province of the court to decide what the law means. I think that whether this Supreme Court would uphold any congressional effort to regulate the court's ethics is an open question.
So, hearing that, do either of you, and I'm not suggesting you have to be court historians, but do either of you think this is new because this is a court that is so divisive, at least seemingly, and at least I would say for this particular group that you're speaking to right now, that is so divisive? Or has this issue been around for a while? It seems to be so out there right now, and everything, we seem to be watching everything that the justices do. And to be fair, I mean, it's not just Alito and Thomas that have been sort of taken out for look, he got this free trip. I mean, even Ruth Bader Ginsburg was chided for some of the things, that gifts she accepted or travel she took, or those kinds of things. So it's not, but this court in particular seems to be constantly watched and taken to task.
I'm not sure we've had a court that's had such extreme divisions on it. I can speak about two people. One of them was a student of mine, Sonia Sotomayor, and the other was a Princeton alum who did everything he could to get me out of my job. He had students following me around whenever I was not in my office, waiting for me to make a mistake. And when I did, he published it in his newspaper and in a headline and said I needed to be fired. And that was Sam Alito. The division is intense.
So Adele, what you're saying is this is different. These are different times.
I don't think we've had such extremes. And I guess I don't put Sonia in that category, but a lot of people would because of the way she votes. But the appointment of Alito was, I mean, I have to blame Barack, who refused to appoint. There were two openings as his term was ending, and he said, I'm not going to do it. I will let the next president do it. And that's had a huge impact, not so much on the shape of the court.
So Barack tried to nominate Merrick Garland, and I blame Mitch McConnell, not Barack Obama for this one. Although Barack Obama could have moved much more quickly and made more of a made it much more of a live political issue than he did.
An issue. Yes, no, I think there's a lot he could have done.
As could Hillary Clinton. But water we can't redo that. What I will say is there have been times in the past when the Supreme Court has been extraordinarily divided and extraordinarily controversial. And there have also been times in the past when Supreme Court justices have done things that are, by today's standards, really quite shocking in terms of ethics. Just to go back to Marbury versus Madison, one of the you may or may not remember in this case, this very famous case that's all about how powerful the Supreme Court is, from 1803. The underlying dispute had to do with something that had happened when John Adams was on his way out the door as president. And it had to do with this attempt to appoint a bunch of new judges. Mm-hmm. There were supposed to be delivery of commissions to these judges. Well, one of the people who was involved in that was John Marshall, who then became Chief Justice and decided the case. So, the ethics that that would be shocking today. There are plenty of stories about justices doing things like advising the president about things that then they decide for themselves, or then come in front of them when they are acting as justices. And sometimes they provided the advice while they were on the court. So we could come up with lots of stories about times justices have behaved unethically, or by our today's standards unethically, and we could come up with lots of examples of where the Supreme Court has been closely divided and there's been an enormous amount of acrimony on the court. I have a theory about what makes things feel different today, and my theory is, at least in part, that it has to do with the way the membership of the court and the makeup of the court has been so severed from the small d democratic process that's supposed to have input into that makeup. And just referring back to what happened with Merrick Garland, and then again after Justice Ginsburg's death, on the flip side, rushing through Justice Barrett's nomination and confirmation. Those are just two recent examples of how that's come about. But if you think about it like this, there are, since 1988, Republican candidates for president have won the popular vote once. That was in 2004. They nonetheless have 6 of the 9 Supreme Court justices were appointed by Republican presidents. Now, this is all constitutional, right? But it's a problem for small d democratic accountability. And the most recent 3 justices, not only were they appointed by a president who did not win the popular vote, but they were confirmed with the votes of senators who collectively represent millions of Americans fewer than the senators who voted the other way. So we really have lost this small d democratic input into the makeup of the court.
So we may get into some of the efforts at changing the Supreme Court, but that's not where I want to go right now. So we're going to hold off on that. And we may or may not get to that because that wasn't where I think we thought we would go. So I want to spend a little more time on this issue of ethics here. Because my second question has a little bit more to do with the first. All of the members of the Supreme Court travel and give speeches and sometimes are honored at meetings and conventions. They also write books and they go on tours to promote and sell them. How does all of this, quote, travel fit in with ethics codes? And is this different than what I'm gonna, and this wasn't in the question I gave you. I added it this morning as I was going over things. What I'm going to call, and this is, I think, a quote from Clarence Thomas, personal travel with dear friends. That's, I believe, a direct quote from him. Personal travel with dear friends. And, you know, how does all this fit in? What he just issued, Thomas just issued one of his first ever reports on travel where he listed 3 plane trips on private planes provided by his friend Harlan Crow. And he indicated that he used his private plane because it was at the time that the report on the, of course, I'm blanking on the abortion case, the leak, the Dobbs case. Thank you. The Dobbs case leak had just happened, and it was a security risk for him to travel on a normal commercial flight. So he took his friend's private flight. That's why he did that. But he reported in this release that he took these 3 private flights, that sort of thing. So my question is how is this different? Is this important that he report these private flights? And is this okay that he's doing this? I'm doing this because it's a security risk for me to fly on commercial airlines. And all of our Congress people fly on commercial airlines. I fly with them all the time when I go back and forth to DC.
So I think that excuse is hogwash. And I don't think it's appropriate. I think that judges, lower court judges, state court judges are adhere to a code of ethics. By and large, everyone has something that's similar. You have to avoid even the appearance of impropriety. I think this looks improper. And I think the failure to disclose was improper. However, I don't think it likely had any impact on any of Thomas's votes on any of the that came before him, because I view him as a very ideologically motivated justice who would likely vote that way in other cases as well. But I think it's very unseemly. And I'm with you, Carol. I think that the ostensible claims of security concerns are overblown, and members of Congress fly on commercial airplanes all the time.
I
Anything
would,
to add?
yeah, I mean, I agree with what Colleen has said. The explanations they're actually, they're hard to accept with a straight face, frankly. And there's a kind of a weird inconsistency in that on the one hand, he's been saying, I don't have to report this, and now he's reporting it. And when he reports it, he's like, well, here's my reason why I had to do it this time. There was a snowstorm, and here's the reason I had to do it this time. It was because of Dobbs. None of it really holds water. I do largely, like almost 100% agree with Colleen that it's unlikely that any of this would have affected Justice Thomas's vote or Justice Alito's vote, for that matter. There is one area where I do wonder, and I didn't come up with this myself. I read it, and now I can't remember where I read it. So unfortunately, I can't credit the person who did come up with it. But they pointed out that Thomas has actually changed his mind about the vitality of what's called the Chevron doctrine. And the Chevron doctrine, I don't want to get too deep in the weeds here, but it basically has to do with who makes certain types of decisions about what statutes mean. Is it always the court, or where there's ambiguity or open-ended language, can administrative agencies that have been, to whom the Congress has delegated the authority to administer these statutes, do they have some say? And it seems very likely that the court is going to overrule Chevron to say that the administrative agencies are no longer allowed that leeway and the deference that goes along with it. Exactly, we don't know exactly what they're going to say. What we do know is that people who don't like regulation don't like Chevron. And we do know that Harlan Crow and his friends don't like regulation. And we know that this would also, overruling Chevron would be another example of the court amassing power in itself, which is something it's been doing a lot of late, and taking power away from other government actors. Now, I do not think that Justice Thomas, to the extent that he's likely to, that he does appear to have changed his mind about Chevron based on things he's written or how he's going to vote. He's not doing that because somebody took him on a private plane. That's not happening. It's a much more, has to do much more with being in a social milieu where people are talking about things, and these are things that are of interest to them. And to be fair, I don't know how different it is from what people on the other side might say about, well, Justice Breyer likes to hang out with all these liberal Yale and Harvard professors, which is kind of true. The one difference, of course, is that they're not taking him on private planes. Another difference is that they're people he knew before he became a justice, by and large. And we do see this, what I think is extremely unseemly effort by the Federalist Society head Leonard Leo to match new justices with bazillionaires who are going to, be their friends now that they're on the court. So, but I think that sort of the social milieu, I think, is a big part of what's going on here.
Well, let me, Colleen, did you want to jump in?
Yeah, I just want to underscore how correct I think Carolyn is for really focusing on the activities of Leonard Leo and the Federalist Society, because I think that the effort by Leo and the Federalist Society to pack the court with judges and justices, judges in the lower courts and justices, obviously in the Supreme Court, who adhere to the Federalist ideology, is a very significant contributing factor to how far right the court has tilted and to the politicization, the further politicization of the nomination process. And I mean, just to be, candid and go back to Carolyn's point about, the first Justice Marshall, and then Chief Justice John Marshall, by virtue of the fact that the federal court judges and the Supreme Court justices are nominated and must be by the president and then must be confirmed by the Senate, it is an innately political process. But I think that, the Federalist Society, under the guise of originalism, has basically, really pushed the politicization in a very extreme fashion. And I think it's really important to be aware of that.
Well, I'm going to just sort of add to this as we look at, I mean, the Federalist Society and Leonard Leo are now the overseers of one of the largest monetary gifts ever given to an organization. I can't remember to the tune of how many millions of dollars.
1.6
billion. I'm sorry. I was downsizing. So sorry. That is almost frightening when you think about what can be done with that kind of money. And with no strings. So Leonard Leo now controls this vast sum of money to be used in whatever ways he wants. The research that was done by ProPublica that sort of opened the doors to a lot of the controversy around Thomas Alito and the gifts that they've received, or is indicated that these gifts were just the tip of the iceberg for Thomas, from Harlan Crow, whose business interests are often before the court. And you mentioned, I don't know whether it was Colleen or Carolyn, that some of the things, and in my next question, I'll talk about some of what's coming down the pike in this session of the upcoming session of the court. But given this, can the public feel comfortable that cases coming before the court are going to be heard without bias? Because it's not just Thomas, it's not just Alito. Other justices on the courts are receiving, as you said, when they are appointed, there are attachments made, not just by, I don't think just by the GOP, but I'm not aware of the obviousness of how that happens on the left. Does it happen on the left? That people attach themselves to justices? As you said, Breyer had his colleagues from Harvard and Yale, but they were there in existence before his court appointment.
So I don't have the background to categorically assess the sort of the ethical wherewithal of all the Democratic appointed justices. But I think that the ones, currently and recently on the court, it's a difference of kind, not just of degree. I think that the kinds of, and I'm going to put ethical in air quotes, the kind of ethical lapses that the justices, I think Justice Sotomayor, for example, are accused of, for example, having her court, I don't know if it was her clerks or secretaries, assist in the promotion, or perhaps even the, reading the galleys on her autobiography, using, federal tax dollars who pay for these employees, to do personal work is a very different kind of allegation that does not go to the presence of bias or the absence of bias in her decision. It's, at most, a bad decision, to use court personnel. It does not taint, for example, I think, or have any suggestion that she decided a case a certain way because she arguably used her clerk and her secretary to do private business. Should she have done that? Probably not. Likewise, I think that the kinds of travel arrangements that former Justice O'Connor, Justice Ginsburg, to name two, Justice Breyer, I think also, of being the guest professor of Notre Dame, has a Italian or has a Rome law program. A number of law schools send Supreme Court justices abroad for a couple months in the summer on the school's dime to teach about American jurisprudence. Again, it seems to me a difference in kind when, the law schools don't necessarily, have matters pending in front of the court for decision, than accepting the largesse of people like Harlan Crow, who do have matters in front of the court. And just to hold up what I think was a great example of wanting to avoid any appearance of impropriety, Justice Brown Jackson recused herself from one of the two cases involving affirmative action in the students for, I'm going to say, unfair admissions versus Harvard and University of North Carolina. She did not participate in the decision of the case involving Harvard because she had recently been on the Harvard Board of Overseers. And so I really do think it's a difference of kind.
I would agree with that. I do think it is a problem for the justices in general that they don't have a code of ethics. I mean, this is a reason why they should, because there are things that the justices on the left have done that are unseemly, and we're going to see reporting on it. And it would be much better for everybody if there were a clear set of rules and there was transparency, and if people actually follow the rules. I mean, one thing that is going on is that Justices Thomas and Alito have not followed the disclosure rules. And I don't think there's evidence of other justices doing that. Although it might emerge, I don't know. So I think it's in the court's interest to have a code of ethics. Justice Kagan, Justice Alito said he didn't think Congress has the power to impose one. I thoroughly disagree with him for the reasons Colleen said. Justice Kagan said she doesn't see how that can be right. And apparently last week at a conference, the Sixth Circuit, Justice Kavanaugh said something along the lines of, he thinks something is coming, that the court is looking at it pretty seriously. And I'm sure that's true, that they're looking at it seriously. And of course, the Senate has been moving this legislation that would require the court to have a code of ethics that they would write themselves. I mean, that's one of the interesting and really kind of clever things about this piece of legislation, is that it doesn't attempt to impose it on the court. It says, court, you got to do this, and you have to tell us what it is, and you have to have transparency about people if there are violations. So that's not going to pass the House right now, obviously, but it's, there's definitely movement. And I think for no other reason than that they don't want Congress to tell them what to do, they're likely to do it themselves.
Yeah, I think that's also very clever, is that the legislation is not writing the code of ethics, but saying you write your own code of ethics, which I think is the way to go, because they can't be accused of imposing it on them. So I want to move to the future, which is only 3 weeks away, the first Monday in October, is the first day of the next session of the Supreme Court. And I only picked 3 cases, and two that I know will happen, and one that I think will also probably happen. Actually, 2 of them will probably happen. One is already on the docket. The one that's on the docket is the United States versus Rahimi, which is the case in which they will decide the law prohibiting the possession of firearms by persons subject to domestic violence restraining orders, suggesting that it violates the Second Amendment. So that if you have a restraining order against you, a domestic violence restraining order, there would be a prohibition against getting a gun. And there now is people saying, no, you should be allowed to have a gun, even if you have a restraining order, a domestic violence restraining order. And anyone who's worked in domestic violence, the area of domestic violence, knows that the chances of being killed by your partner, your domestic violence partner, are greater if they have access to a weapon, particularly a firearm. So that case is already on the docket. There is expected, and let me get to my notes. On Friday, these questions were written before Friday, but on Friday, the Department of Justice asked the Supreme Court to decide if the abortion pill should remain on the market. So that the question of whether, now that the Fifth Circuit made its ruling on mifepristone, the court will probably now be asked to whether or not they will take a case on mifepristone. And so I think that's going to also be a major case that this court, which thought it was done dealing with abortion, will now again be dealing with abortion. So that's a second case that I think this court, of great interest to Chicago Women Take Action. And the third one that I think will probably end up before the Supreme Court is whether or not Donald Trump can run for president in certain states that may bar him from being on the ballot because of all the criminal charges against him and some rulings that are going to come down against him. So my question to our 2 wise panelists is, what do you think? And I'm not asking for predictions, but given the makeup of this court and the leanings of this court, and just for the sake of throwing something else in the docket, I expect also, because there have been so many voting rights cases in the courts, that there will be at least 1 or more cases on voting rights gerrymandering before the 2024 election that will reach this session of the Supreme Court, because they are all over various states. I mean, we've already had Alabama defy the Supreme Court ruling and get slapped down for it and try and get out of it again. So who knows what's going to happen there. So we could throw voting rights in again too. So what do you think on any of them?
I'll
You want to go first?
Yeah, I'll be quick because I really want to hear what Carolyn has to say on this. I think the the Second Amendment case before the court. I would be flabbergasted if the court didn't strike down that requirement. I think the court has shown absolutely no regard either for the explicit language of the Second Amendment. Its history is bad. And the fact that, as you said, Carol, victims or survivors of domestic violence are more likely to be killed if their abuser has access to a gun. It makes no difference to this court, the majority of which I think is steeped in misogyny. And I'm looking at you, Sam Alito. And on the mifepristone case, I fear that we could see going back to Carolyn's discussion of the Chevron doctrine. I fear that we could see the court use the quote unquote made up major questions doctrine to say something to the effect of, the FDA didn't have authority, particularly with respect to broadening access to mifepristone, because Congress never intended to delegate such an important political question as abortion rights and access to an administrative agency. And on the Section 3 of the 14th Amendment of whether Trump should be disqualified or barred from running for office because he participated in an insurrection against the United States, I don't look, unfortunately, for this court to uphold that, which I personally think is applicable here. I think that I'm not persuaded by all of the pundits who say this is a political question. We should let the voters decide, because what are they going to say? When I come saying, well, then let's just get rid of the Electoral College because let the voters decide. And as Carolyn said, the voters have decided all but, one election, that being, 2004, in the last, 20 some years, Democrats have won the popular vote. So let's just, the Electoral College doesn't apply because let's turn it over to the voters. So anyway, that's my quick take on it, my quick dismal take on those three decisions. I'd love to hear Carolyn's view.
Well, I guess I'm marginally more optimistic, or maybe marginally less pessimistic might be a better way to put it. I think Rahimi, that's the gun case, is actually going to be a hard case for Kavanaugh, Barrett, and Roberts. I don't have, the other three, Alito, Thomas, and Gorsuch, they're going to do what they're going to do. But I think that the other three are less, they're much less doctrinaire about originalism. I mean, let me be clear and say, I don't think that what the court is doing in these cases, like in Bruin and Adopt, is real originalism, or is, it's manipulative originalism, but they are willing to think, at least entertain the possibility that the consequences of their decisions should be relevant to how they decide them as a matter of constitutional law. So I think that case is not so predictable. With mifepristone, I have to admit, I don't know enough about the ins and outs of the statutes that are at play here to really be able to say, could this possibly be a major questions doctrine case? There's an easy way for them to get rid of this case without actually deciding it, which is standing. The plaintiffs in this case, if like one of my law students put it in their exam, if I had given this hypo and they're like, oh yes, of course these people have standing, they would get a bad grade. These plaintiffs don't, under any normal set of rules about who gets to sue in federal court, they don't have standing. And that would be my prediction, is that the court is going to try to just punt and not decide the mifepristone issue. Now there was a third one. Now I'm blanking on what it was.
It was
14th Amendment.
Oh, yeah. Oh, I don't think they're going to want to decide that. I mean, I think that and I'm not, I am very unsure, frankly, about what I think about how this question should be resolved. There are a lot of different arguments out there, and I haven't figured out in my own mind what I think the right answer is. I do not think he's eligible. Let me start there. I do not think he should be able to run for president or serve as president, because I do think he violated the terms of Section 3 of the 14th Amendment by participating in and inciting an insurrection. But how that gets implemented, and who's going to take responsibility for it, or more likely, is nobody going to take responsibility for it? I just don't know. And I genuinely have not reached a conclusion myself about that, because I do care about consequences. And there are a lot of very tricky questions about how different paths would play out. On voting rights, I do just want to add, there is a voting rights case, leaving aside Alabama, which I think the Supreme Court's going to smack Alabama down. I mean, I don't, the news reports say, oh, they think Kavanaugh might flip. I don't see that happening, based on what he said, a few months ago. So I think they're going to be pissed that Alabama is defying them. So that's my best guess about Alabama. What I'm more worried about is the case that's coming out of South Carolina. Case out of South Carolina about racial gerrymandering, in which the plaintiffs established that the maps drawn by the South Carolina legislature were motivated by race, or that race predominated, to use the technical language. And I'm not real familiar with the record or the facts of the underlying facts of the case, but the court keeps making it harder and harder and harder for civil rights plaintiffs to show that race was a motivator, at least when they're not white people. So those plaintiffs. So that makes me nervous.
okay. We're just about out of our discussion time, and we're going to move. We've got a few really pithy questions. And so just sort of to wrap things up somewhat. In a July poll, 62% of Americans believed that the court had a legitimacy crisis, and the court's popularity with the public is at the lowest that it's been in nearly 2 decades. Do you see any ways in which this particular Supreme Court can regain its status with the American people? What would you suggest we be looking for during the upcoming session that will begin on the first Monday in October?
Well, I mean, imposing an ethics code on themselves would be a smart thing to do. I've never been really it's never been an issue I got very exercised about, in part for the reasons that Colleen, suggested, which is I never really thought it would make that much difference to how they rule. And I still think that, but boy, would it be dumb of them not to do something, because it is something that most Americans who pay any attention to the court are worked up about, because it looks terrible. It looks completely terrible. So that would be a smart thing for them to do. And as I said, there's some reason to think I'm sure they're talking about it. Whether it will actually come to pass, who knows? I think that, there were these 2 cases last term that came out well, I guess I would say. There was a case called Moore versus Harper and a case called Allen versus Milligan, and they were both cases about voting and elections, and they both came out well. I'm not going to get into all the detail, but the Allen versus Milligan is the Alabama case, where Alabama is now refusing to do what the courts have told them they have to do, the white people in Alabama. there was a lot of kind of commentary at the time about, oh, see, the court's not so conservative. It's, it's moderating itself, which I just thought was a bunch of hooey. And largely, I thought it was a bunch of hooey because those cases at best were status quo cases. They didn't, and they both of them did very pointedly leave the door open for some future shenanigans. I think at least with Moore versus Harper, that was inevitable. Not so sure about the other case, but they didn't change the law in a good way. And when I look at the array of cases that we've talked about and the other cases that are pending, at best, we're playing defense. And the best that's going to happen is things won't get a whole lot worse in certain areas of the law. So I guess I would say the thing to look for is how much appetite for disruption does it appear they have? Because, Dobbs, I think it's possible that Dobbs and the reaction to Dobbs has given them a little bit of pause in terms of, we only have so much capital. How are we going to spend it?
I wish I were as either optimistic or less
I'm
pessimistic.
not optimistic.
Less. I wish I think I'm more pessimistic than Carolyn. Although I totally agree with what she just said in terms of Moore versus Harper and the Alabama voting rights case really preserving the status quo and not reflecting a turn in the court's appetite for ideologically motivated outcomes. But I think that I don't look, Carol, to go back to your question, I don't think that there is anything short term that the court can do to quickly restore its legitimacy, because it is so out of step with the American public on a range of issues, whether it's abortion or whether it's that individuals should decide who they're going to marry, not the government, or whether it's just fundamental voting rights, that states shouldn't be able to gerrymander, or states shouldn't be able to suppress voting on the basis of race or any of the other or ethnicity. And so I think the court is really out of step with the American public. And one of the ACLU of Illinois board members is professor at the University of Chicago Law School, has written extensively on I think, folly of relying on the Supreme Court to protect rights, and that the Warren Court's protection of a range of civil rights and civil liberties was an aberration, a very positive aberration, but by and large an aberration when you look at the court's 200 plus year history of really by and large protecting property interests and not being a force of protection for individual rights. And in fact, really the concept of using litigation in the Supreme Court ultimately to protect individual rights is something that's really only gained real currency from the 1950s on. And maybe a little bit before. I mean, there were a few significant cases in the 40s, maybe a couple in the 20s. And so for me, that sends a message that we need to really exercise our other advocacy tools, whether it's state Supreme Courts or state courts, as you mentioned, and as Carolyn has been so vital in moving for, and to really use the political process, as I think we've seen advocacy groups and voters do post-Dobbs. and really not wait or depend on the Supreme Court to protect these fundamental rights.
So let me, with things hanging as they are, let me move to some of the questions. We won't get to all of them in the chat, but I'm going to take a few minutes to get to a few of them. And then if there are others that want to ask them, raising your hand, and Judith or somebody who can see the full screen can call on people, because I can't see, I don't have a full screen view so from my iPad, so someone will have to help me with that. But Hetty, who I don't think is still on, just wanted to know if the state, something about the state Supreme Court codes of ethics. Do they have them, and who makes them? So can either of you just do a quick response to that regarding state Supreme Courts?
Every states set their own canons of judicial ethics. There's a set of model canons of judicial ethics that the ABA propounds, and I'm not an expert on state level judicial ethics. I really can't say to what extent every state has adopted precisely what the ABA has suggested, and there are differences between states.
Yeah, I've just jumped into that for Courts Matter Illinois myself, and I'm just learning the ropes on that. But I think that's what I'm learning as well. And Judith Cossey asked, what if a Supreme Court justice doesn't recuse themselves from a case where they should be recusing themselves? Is there any recourse?
No. And the only ultimate recourse, and I don't think it's been threatened since Earl Warren was threatened with impeachment, is to try to impeach a Supreme Court justice for misconduct, because Article 3, which again is the judicial code, basically says these are lifetime appointments, for good conduct, and you'd really have to try to show a misconduct, and I think a breach of judicial ethics, could be a impeachable offense. But to go back to something Carolyn said, I also care about consequences, and I think we have to be mindful of that. But for me, that's a really sticky wicket, because I think that we're seeing with the threatened impeachment of President Biden, the Republicans making good on their threats to impeach the next Democratic president because of the two impeachments of President Trump. But again, if you don't try to enforce these prohibitions on misconduct, what good are they? At a certain point, you just have to say, if we don't draw a line somewhere in the sand, we are really in a situation where anything goes.
So there were a number of comments, questions in the chat, including one from Jerry Kahn, who wanted to, in essence, saying, so what can we do? We're here, we're learning this stuff. It's not pretty. And we feel like, what do we do? These are lifetime appointments to a federal court. What can we do? And,
well, I mean, first of all,
I have my own answer, but I'm going to turn to the two of you first.
Well, I just want to echo what Colleen said about using other advocacy tools and that there is a certain amount of there's an argument that relying too heavily on the courts to protect rights has not been a wise move, that it has made people somewhat, complacent in certain ways. These are big, complicated social and historical arguments. So I don't want to weigh in too heavily on one side or the other, but there's no question that right now we're not helpless. We might, there are other advocacy tools of many types. And Colleen talked about state courts. There's electoral politics. Those are incredibly important. I know there are some people who've asked about court reform, and I think that's a really important pressure point right now. I think that we could get into the details, but I think that there is a strong argument to be made that it is appropriate under current circumstances to add seats to the court. That's not something I used to think. I used to think it was too dangerous to do that because we'd run into this, tit for tat situation. But I do think we're at a point where the court is, as I said, so disconnected from the small d democratic input that is supposed to be part of it, that we need to rethink it. And it has gone so far in adopting, in amassing power to itself, and it's going to continue to do that. That's I think also quite dangerous. There are ways of expanding the court that are not necessarily as obvious as other ways. I mean, the obvious way is you add 3 or 4 seats. You sort of make the argument for why then that number is appropriate given, what happened with Garland, what happened with Barrett, et cetera. But there are other things you could do. You could add, there's a guy named Elie Mistal says, add 15 seats, add 20 seats, make them sit in panels, change the nature of the court. There are some other thinkers who've said, well, have 10 justices, and then they have to choose 5 other judges from the lower courts. And I mean, there are a lot of different models that are entirely constitutional that might be both stable in the sense that wouldn't necessarily provoke the tit for tat. Well, you added 4, now we're going to add 4. So something that both sides might be able to live with. And that might also turn down the temperature a little bit the one argument is if there are a lot more judges or a lot more justices, we're more likely to see the justices behave with a certain amount of restraint because they're not going to be able to convince as many of their colleagues. Now, these are, this is all speculative, but I don't think we should just accept the idea that the court, the way it's currently operating is the way it has to operate.
I agree. And I just wanted to say that there's real peril in not considering all of these other tools, including enlarging the court, because there's still a lot more damage that the court could do. And I think we saw a hint of that in the affirmative action decision with the court's insistence against the historical record of quote unquote race neutrality in a system that's anything but. And were the court to, going back to the abortion issue in Dobbs, were the court to accept the arguments that the anti-abortion crowd have been making for decades, that the right to life begins at conception, and is entitled to protection under the Constitution. That kind of ruling would essentially eviscerate the state constitutional protections for abortion and the state statutory protections that we've put in place. And so the mischief that this court has done, is far from as bad as it could really get. And I think just going again back to the abortion issue, there are at least three justices, Alito, Thomas, and Gorsuch, and maybe Barrett, who would be amenable to the right to life begins at conception argument.
Well, I just also want to say that we need to pay attention beyond the Supremes. And I think that that is something that doesn't always happen. And I think when we pay attention to what is happening in the federal judiciary writ large, meaning the appellate and district courts in the districts across the country that are also lifetime appointments being made by the Senate, and voted on, and Durbin has been making nominations, and good nominations for the most part. I think there's only been one or two that Courts Matter Illinois have opposed, and that was very weird. When we opposed them, we couldn't understand why he picked these people, and he's picked diverse in both ethnic, racial, and background, in their legal backgrounds, people to fill these positions across the country. And he's almost at a point. Dick Durbin has been good about moving them through the Judiciary Committee. Pay attention and support what is happening so that we can get these positions filled, because that's helpful. These cases that we talked about tonight don't automatically jump to the Supreme Court. They go through the lower courts first, and most of them don't get to the Supreme Court. So the decisions are made not at that level. So you want good people there. So, that's one. And pay attention to your state judiciaries as well. Now, every state is different. Illinois has very strange election laws for its court systems. I'm still figuring them out and trying to get much more knowledgeable about how they work, because it's very different when you look at our judiciary in the Chicago metro area than when you go downstate and look at the systems there. They're all connected, but they don't function the same, right? So you want to be very careful and understand the judicial systems, and not blow off the fact that if you live in the city of Chicago and you've got 64 judicial checkoffs you've got to deal with, don't blow them off. Get some information and do that. So, that's what Courts Matter Illinois works on, is educating the public about the courts writ large, so that not just the state courts, but the federal courts. And originally we were only the federal courts, but we recognized we got to be a little broader than that. So my suggestion would be, what can we do? We can educate ourselves and then educate others, or, we're going to get what we got. And
could I just like to add one other pressure point that I think is really important. Senator Durbin, who has done many, many great things as chair of the Judiciary Committee, has not been willing to move on blue slips. Blue slips are, would allow senators to not allow a district court judge in their home state to move forward. And he's insisted on honoring that system. He says, well, if we don't, if we don't honor it, then they won't honor it when they come back. And I don't think they're going to honor it anyway.
They haven't.
But more importantly, at least from my perspective, is what it's meant is that while Biden has appointed a lot of really, really outstanding judges around the country, district court, trial court judges, and circuit court judges. Really, really outstanding people with backgrounds that we've never seen in these kinds of numbers on the courts before, both in terms of racial and ethnic diversity, but at least as important for this purpose of professional diversity, people who are civil rights lawyers and public defenders, et cetera. But we're nowhere, we don't see that in the South. That's not happening in states like Texas and Alabama because the senators won't allow it to happen. And I really think, I've asked Senator Durbin about this. He didn't,
too.
I didn't persuade him, but it can't hurt for him to hear from more of us. So I'll just leave that there.
No, I agree with you, Carol, and Courts Matter agrees with you also, that the blue slips have got to go. And there are areas where Senator Durbin is just too nice. And that's the best way I can put it. He is too nice. And blue slips are one of those areas. So
Carol, can I make one comment before you go?
Sure.
Sign off. Ben Winkler, who you, I believe, were the person got him to be our speaker, was on our progressive mobilization call today, and he's asking that people, I think someone put part of it in the chat, that people go to justice. Wait a minute, just a second. I want to say it right. defendjustice.com and get the information and ask anyone that lives in Wisconsin to please go to write to their legislators about them trying to impeach the new Supreme Court justice. And I just think that we ought to, where we know people in Wisconsin, or if we're willing to go to Wisconsin and help, we ought to get involved in that fight.
Yep. They're
defendjustice.com.
Yeah, they're newly elected Supreme Court justice. They're trying to impeach her
before she can make any rulings.
Yeah. So let me thank our two C speakers, Colleen and Caroline, for a really stimulating and interesting time this evening. I really appreciate your wisdom and your words. I'm going to turn the program over to our chair, Jackie Grimshaw, who did make it. Thank you, Jackie. And to see if there are any reports and close us out. Jackie. To go.
I just always have to get the right buttons going here. So thank you, Colleen, Carolyn, and Carol. I mean, we had C's times 3 today. So that was awesome. All you C guys were absolutely magnificent. So yeah, I'm sorry I have trouble getting on, but that happens. And I started early too, just fumbling. But let me ask quickly from any of our committee chairs, if you have anything to report for this month, any planned meetings or sessions coming up, anything that everyone should know about. Betty?
I'm just gonna,
and
I just to let you know that Deb Rosenberg and Mary Driscoll have prepared an amazing newsletter about healthcare and the privatization of healthcare, the bills that are up, and what to support.
You cut out again, Judith, I think.
I'm sorry?
Your last sentence cut out.
Oh, that's coming up in our newsletter. We'll send it out broadly.
Yeah, I saw it today. It's awesome.
Yeah, it is really, it's quite detailed and very specific, and I think very, very informative. So
yeah,
that's
we conflicted with a standing meeting they have by moving our meeting to the second Monday. Otherwise, they would have been here. But we didn't want to do Labor Day, and so we always have to lose people. when they have standing meetings. Okay, so that's health. What about, anything, Judith, moving on the agenda meetings?
The agenda, Marilyn is taking, she said she would look this weekend at the agenda to do an edit. It's been requested that we add a housing issue. So hopefully the Chicago women's agenda will be out soon, and we'll gather our partners to look at it and specify some actions. And then we'll move forward, seeing about getting before the city. So that's coming, you know, a bit. So stay tuned for that.
Okay, thanks, Sherry, for posting the website. Donna and Betty, do you have anything in terms of updates?
Well, the only thing I had was the Wisconsin piece.
I
Okay.
think that I'm gonna invite anybody on this call. I see we have new faces here, and if they'd be interested in the anti-racism committee, please just put it in the chat and I'll get in touch with you. We had one great meeting and we decided that the one thing we want to do is put the idea in all committees. We want to plug in how structural racism affects health, environment. Every committee that meets, one of our goals is to make sure that there is a recognition of that, the unfortunate, systematic problem that's going on forever, that is embedded in everything that we profess here. So whether it be communication, whether it be health, environment, it's all there. So that is going to be our call to action at the next meeting, that we want to see everybody, just make sure that they're aware that that has to be part of their program, or at least a recognition within their program that that exists. So, but again, anybody who is interested, oh, please add me. Oh, we have a new person. Look at that. Intisar. Thank you. I'm popping this down right now. We will be in touch. Welcome. So, of course it's okay. Yeah. So polite too. Okay. All right. So wait,
All
don't
right.
get off the
Thank you.
chat. I have to write down your name because, am I saying it right? Intisar? Is it? Unmute yourself. Intisar?
Yes, that's right. You can call me MT.
Inti.
Auntie, how cute. I like that.
Yeah. You're so nice and fresh and young. Okay. we always love to see that. ALKHA. I bet no one gets that spelled right off the bat, do they? No. Okay. No. It's Inti. Okay. Yeah. Well, yeah, for sure. We're going to be in touch. Thank you. And anybody else who has, or knows people that want to be involved, but we need young, fresh faces. So thank you so much for stepping up to the plate here.
Okay, both of our environmental chairs are not here tonight. But
Yeah,
one of the things, and neither are our communication chairs.